All right, hey Spanish Springs. So this lecture is for 0 period and it covers page 7 and just to the top of page 8 and ends at letter E, all right? So the other class, I'll finish the 8 and 9 tomorrow. I'll post that for the rest of this 7, 8, and 9 in the notes. All right, so today we get into the highest court in the land, which is, of course, the Supreme Court. A couple kind of overarching things is, remember, it's the only court specifically mentioned in Article 3. The judicial power will be vested in one Supreme Court. And remember that all the other lower courts were created by Congress at the federal level. States are their own issue in the concept of federalism. So on the bench, we have 8 associate justices and 1 chief justice. Now, they're essentially equal. We'll see as we get through a couple days that the chief justice does have some powers over the others, but he's just generally the most equal. All right. So the number of justices is set by Congress, which I'm not quite sure when, but it's been 9 for quite some time. I think originally it was 12. At one point it was 6. But the tradition is at 9 right now. It's good. It's an uneven number. Okay. And so remember that of these 9 seats, the highest court in the land, they're going to go through the Senate Judiciary Committee for their hearings. They're going to get their American Bar Association ratings, right? I think the highest is the highest actually is a highly qualified. Let's see. Well qualified, qualified, and not qualified are the ratings that the ABA will give the Judiciary Committee as they vet the Supreme Court justices, the nominees, to go onto the bench. All right. It is the highest court in the land. This is where kind of all other appeals from the state courts, from the federal circuit and district courts, from the military courts, all those Article 1 courts, you can eventually appeal to the Supreme Court, and that's kind of the last resort. If you lose, you're kind of out of options in a simplistic terms, all right? Now again, the key powers that we know the Supreme Court has. Marbury v. Madison, when they struck down Section 13 of the Judiciary Act of 1789 with Chief Justice John Marshall, established the power of judicial review. We also know that when we read Federalist 78, that it hints at it is the proper and peculiar province of the courts to determine what is constitutional or not. And that's a paraphrase. So the Constitution itself does not say judicial review. It says the judicial power will be vested in the Supreme Court. But judicial review was established over federal actions in Marbury v. Madison and Martin v. Hunter's lessee over state actions. All right? And we've seen them use the power of judicial review thousands of times at both the state and the federal level. They've struck down federal law, they've struck down state law, executive actions of both the gubernatorial, governor, or the executive branch. All right. The other thing is, not only do they have the power to strike down or uphold legislation, they have the power to interpret the Constitution. You know, for example, commerce is a broad element of the Constitution. Necessary and proper, all the inherent powers, the implied powers, equal protection, due process, how do we define liberty? There's broad elements to our Constitution that are in need at times of some clarification. And these clarifications or these definitions of the Constitution can morph over time. As we've used again and again, the Plessy case defines separate but equal as the Equal Protection Clause's meaning. And then when we get to Brown v. Board and all the other civil rights legislation, separate but equal was not equal and therefore redefined the Equal Protection Clause. And so when we have people, whether it be the executive branch, the legislative branch, state governments, individual citizens, etc., challenging the definition of parts of the Constitution, if the case has merit and makes it to the Supreme Court, they ultimately, at that moment in time, have the final say in what the Constitution means. The other thing is they have the power to interpret broadly worded laws that are written by Congress. I would even think rules and regulations written by the bureaucracy also are something you can add to that the courts, if you can interpret as either defining the rule and regulation or upholding it or striking it down as constitutional. And then the other big thing, don't forget this concept of stare decisis that comes from our common law history. Precedent. Precedent gives stability to our legal system. They will define the Constitution at one moment, and ideally under stare decisis and precedent, that precedent is a good precedent, and so all the other lower courts in the country can use that precedent when they need to interpret that element of the Constitution or that law. Now, society changes and evolves, and precedents get overturned, as we said with the Plessy and the Brown. And so courts can reverse themselves, their precedents. Usually what will happen is you'll have judges in one court, and then maybe 10, 15, whatever the time is later, they can reverse their decision or overturn it because the makeup of those judges are different. Those judges reflect the political changes of our society. And so they will adapt to society. All right. Now, jurisdiction is the ability for the court to hear a case. The Supreme Court has both original and appellate jurisdiction. The vast majority of their cases come to them on appeal through appellate jurisdiction. Very rarely does the Supreme Court hear cases on an original jurisdiction basis. I mean, the vast majority come from appellate jurisdiction, all right? They have original jurisdiction when ambassadors are involved and citizens of multiple states are involved, all right? And then everything else is on appeal, right? And this is like something really key. The Constitution defines when the Supreme Court has original jurisdiction. So what that means is Congress, statutorily, through statutes or legislatively, cannot change the jurisdiction of the Supreme Court through law. They could amend the Constitution through a 2/3 proposal and a 3/4 ratification and change the jurisdiction of the Supreme Court through a constitutional amendment, a formal constitutional amendment. But other than that, the Supreme Court's jurisdiction is very much defined by the Constitution. All right? Now, the kind of technical details of how a case gets to the Supreme Court. One of the things you want to look at is on page 367 in the text, there is a chart, figure 10.4, which talks about the number of cases that appeal to the Supreme Court and the number of cases that they hear. All right? Roughly 100 million court cases are filed in this country at state courts and federal courts. Of those 100 million, roughly 9,000 of those cases will appeal to the Supreme Court to be heard. And of that, it's an average is about 80 to 90 court cases that the Supreme Court will take in a year. They work on a 9-month cycle, all right? And so during that session, or that term, they will take about 80. Now this can fluctuate, all right? But that's about, like if you look at the trend has been going, they're taking fewer and fewer cases. And so I think you should know roughly 80 to 90, all right? Now, to get the Supreme Court to hear your case, there's a couple things. One, there has to be a good reason for the Supreme Court to hear your case. Usually what they take are those cases in which they believe when they make a ruling, that ruling will give all the other government agencies, be it the other federal courts, the state courts, police officers, legislators that write law, the definition of that part of the Constitution, some kind of precedent that guides the rest of our society on that part of the Constitution. Generally, the term is they will take cases that are ripe. So if we have, let's say, the circuit courts, in the 9th Circuit Court, the 4th Circuit Court, the 1st and the 3rd, they're all interpreting the Equal Protection Clause differently. The Supreme Court may take one of those cases so they can make a ruling which gives an interpretation of the Constitution or of a law, so those judges on the circuit court and in the district court know how to interpret that Constitution. Because then, if they get a good precedent, what will happen is somebody loses at the district court. They appeal to the circuit court. And the circuit court, using the precedent from the Supreme Court, will say, This is what we think the Constitution means based on precedents from above. And let's say you lose even there. What the Supreme Court will do is they will look at that appeal that you gave from the circuit court and they'll go, nope, we agree with the circuit court decisions, it's good. And ideally that's what precedence does for our legal system. All right? No, it's called the rule of 4. If 4 of the 9 Supreme Court justices agree to hear a case, they will hear the case. So there's 9. So this is one of those cases where a minority can actually win the day. Now it's called, what you want, when you apply to the Supreme Court, you're applying for a writ of certiorari. We can call it a writ of cert if you want. But if the Supreme Court gives you a writ of certiorari, that means 4 justices have said, we want to hear this case. And they've granted you a writ of cert, and then you'll be given a date somewhere down the future to argue your case in front of the Supreme Court. Now, one of the things that I need to mention are the law clerks. Federal judges and even state judges, but I'll just speak to the federal judges, have clerks. These are generally recently graduated law students, and law students will apply to clerk for a justice. They can clerk at the state level, they can clerk at any of the district, circuit, or supreme, but as you can imagine, the clerks at the Supreme Court are the best and the brightest our country has to offer from that year's graduating class of law students. They come from the best schools, they have the highest test scores, they're incredibly bright, hardworking, whatever. You can imagine it being a sought-after job. Law clerks help go through those petitions for writs of certiorari. They're guided by the justices, but they will go through. They are, working for those justices, and they're assigned to a specific justice to go through all those thousands and thousands, 9,000 roughly, applications for a writ of cert. Now, with the guidance from the justice that they work for, they'll look for certain things in certain court cases. It's an incredibly prestigious job. They also do a lot of research to prepare the justices for writing the decision in the case. And we'll get into clerks a little more, but I really just can't stress enough law clerks. All right? Now, the rule of 4, now think about this. If they deny it, there's a number of things. There's no substantial federal issue, meaning it's purely a state issue and not a constitutional or federal issue, and therefore they'll say, let the states keep it. All right? Somebody lacks standing, which we've talked about before, or the upper court agrees with the lower courts. They like that decision. All right? Now, the other thing is this idea of a political hot potato. Ideally in our society, the democratically elected institutions of legislative branch and the executive are writing and enforcing the law. And there's going to be controversial issues. The Supreme Court will take them when they think maybe the country's 50-50 or close, there's some division that needs some clarification. But if 50 states have outlawed same-sex marriage, the Supreme Court's not going to take a case, generally, this is a generalization, that overturns those states. Now they've heard a case about same-sex marriage, and it's because some states have legalized it, and some states have continued to not recognize same-sex marriage. And therefore they feel that that case is ripe and ready to be decided, and it's all about the Equal Protection Clause, which we'll see what they say. All right, so sometimes they don't want to take cases that maybe the president won't enforce it. Congress will ignore that decision. The people will ignore that decision. They want to let the real political issues be fought out on the other arena and try to only get involved when there's really a constitutional issue that they feel they can give some clarification to. Does that make sense? Okay. Rule of 4, if 4 of them grant you a writ of certiorari, they'll hear the case. Roughly 9,000 of the 100 million cases around the country apply for a writ of cert, and of those roughly 9,000, about 80 to 90 are heard. Okay. And then finally, all right. Now, when the justices accept a case, they decide whether they want to get more information or they can issue what's called a pure curiam opinion. In an appeal for a writ of certiorari, one side will give all these legal documents outlining the case. And sometimes the Supreme Court will get those documents and they'll say, this is enough information for us to make a ruling. And then they don't need to hear from the lawyers. And so they can literally write a decision, and it's called a pure curiam decision, when they don't need to hear from the lawyers. Now, I'm not quite sure the number of cases they decide on a pure curiam basis. The one case that we know that is pure curiam is Buckley v. Vallejo, which ruled on the constitutionality of some of the elements of FICA, which was all the way back, in Unit 2 and Unit 1, I think. All right? But generally, if the Supreme Court grants a writ of cert, what they will do is they will request more documents, and then they will schedule oral arguments. And the way oral arguments work, and we're going to get into this a little bit later, all right, more in detail, but each side gets 30 minutes to present their case, each side. And generally, and it's pretty interesting, and we'll watch some of this, is most lawyers prepare for this, they got 30 minutes to go. But usually what it means is the justices themselves are going to interrupt these lawyers and ask questions about the case to clarify in their mind how they might rule. All right? So it's gone from those 100 million court cases to people applying for a writ of certiorari. If the Supreme Court agrees to hear, they will grant a writ of certiorari, and then they will usually schedule oral arguments in which you get a date to argue in front of the Supreme Court. And we'll get into a little bit more of that tomorrow, but zero period, that's kind of, we're done. All right? This stops at the top of page 8. All right? All right, Cougars. I don't have any extra credit except maybe... How about the details of the Federal Election Campaigns Act, which is Unit 1 or Unit 2, but I think it's Unit 2, campaign finances, all right? Study up on that law, all right. Oh, and how about McCain-Feingold legislation? Look at those two. I'll put some extra credit questions on that. All right, bye.